So we got involved in the case in 1988, 3 years after John's trials, after his conviction had been affirmed by the Louisiana Supreme Court. And we were working on John's case for about 10 years before we had any significant break that worked to John's advantage. And we handled the case in all of the federal and state courts in Louisiana. The state trial court, the state Supreme Court, and then on to the federal court system. And so we were raising a number of issues that had to do with the fairness of John's trial, issues under the U.S. Constitution, issues under Louisiana law. And I have a slide here about some of the issues that we raised. But I think the thing that's important to me about this is none of the arguments that we had at that time really had much to do with John's innocence. We didn't have evidence of John's innocence during this 10-year period. John had always maintained to us steadfastly that he didn't do this, that he had bought the ring and the gun from Freeman, but we didn't have any hard evidence that we could go to the judges with and say, look, this man didn't commit the crime. And most of our arguments had to do with various things about the way the trial was handled that showed to us very clearly that he had received an incredibly unfair trial. But as I said, very little of it, if anything, had to do with John's innocence. So we were handling the case, as I said, for about 10 years through every court that you could possibly imagine. And after that 10-year period, we had essentially run out of appeals. There had been 7 death warrants that had been signed along that period of time, but each time we got a death warrant, there was always another court that we could go to as a matter of right and say, you need to hear this case and you should stay the execution until you've heard the case. But in the spring of 1999, we had run out of appeals. And in that time, we knew when we had a petition for the Supreme Court to hear the case back then. We thought it was incredibly unlikely that the Supreme Court was going to hear the case. We had re-engaged a private investigator to go back, and we had given her a checklist of about 50 things that we wanted her to go back and double-check. One of the things that we asked her to go back and double-check was whether there might have been some blood evidence, some kind of scientific evidence from the carjacking case. And I'm going to get to that in a minute. But we were desperate at this point. We thought it was pretty likely that John was going to be executed. We were waiting for the last appeal to run out, and we were preparing ourselves for the very real fact that John Thompson was going to be executed. This is, and it's very hard for you to see this, but this is a copy of the 8th and final writ of execution for John Thompson. It was signed on April 16th, 1999. We received it in our office on a Friday, and we concluded, my partner at Morgan Lewis, Michael Banks, and I concluded we needed to fly down to New Orleans and tell John that he was going to die. This was not the kind of news we were going to be able to tell him over the phone. We couldn't call him and tell him we were coming because he knew what the timing of things was just as well as we. We needed to get down there and tell him face to face. So we got on a plane that Monday morning, and Michael and I began to talk about how this conversation with John was going to go. And it was, I will tell you, an absolutely excruciating plane ride, in part because we had come to believe in John. We didn't have the hard evidence at the time to back that up, but we had gotten to know him during the time that we had represented him. And we saw small acts of kindness and decency that he had engaged in. We saw that he had somehow managed to develop a relationship with his children, even though he was in prison and several hours away from where they lived. And it was absolutely excruciating to fly down to Louisiana to tell a man that we had known for the last 10 years and grown to like and respect that we had failed him, and that as a result he was going to die. We knew he was going to ask us to go to the execution, And I have to tell you, I knew I was going to have to go, but I didn't know how that was going to change me if I had to witness that happen. And I knew it was selfish for me to think that way, but I was very concerned about how is this going to affect me to sit there and watch my client and friend get executed by the government because I had failed him. We didn't know whether he'd be angry at us for failing. We just didn't know what to expect. And we certainly didn't know he was going to react the way he did. When we walked in to see John, he immediately knew why we were there. And all he said was, "What's the date?" And it was Monday the 19th of April. And I looked at John and I said, "John, it's May 20th. And he hung his head and he didn't say anything for a minute or two. And then the first thing that came out of his mouth was, "John Jr. is the first person in my family ever to graduate from high school. His graduation day is May 21st. You guys have to promise me that after I'm gone, you're going to look after him." And he spent the next 20 minutes not talking about how could we save his life. He didn't talk about why we didn't do this or why we didn't do that. He wanted to make sure that we were going to look after his son after he was gone. And so when we walked out of that prison, I actually felt worse than going in, because I asked myself, how is the world a better place for executing this man? How is the world a better place to take this man away from his family and away from other people? And I really felt incredibly low, as did my partner, Michael Banks. We drove to New Orleans, and it was mostly in silence because neither one of us knew what to say to one another. And we were heading down to meet with John's mom and his young son, John Jr., to tell them that their son and father was going to be executed. And about halfway down the trip, something really remarkable happened. I picked up my cell phone and called voicemail, and there on my voicemail was a message from our private investigator. And she said in a very excited message, "You have to call me right away. It's really big. It's huge. Call me right away." So I picked up the phone, called her, and what she had discovered was this document. And again, this is going to be hard for you to see, but it is a report from the New Orleans Crime Laboratory, dated 2 days before the carjacking trial. And what it shows is the district attorney's office knew that there was blood evidence from the carjacking case. And what had happened was Jay Lagarde, when he kicked the perpetrator in the face, gave the perpetrator a bloody nose. And the perpetrator bled on the pant leg of Jay Lagarde. And the district attorney's office sent that pant leg out for testing and got the results back 2 days before the carjacking trial. And it showed that the perpetrator had type B blood. John Thompson had type O blood. The brother had type O blood. John Thompson could not have been the perpetrator to a scientific certainty, yet this document, or the existence of scientific evidence, was never revealed by John Thompson's lawyers, to John Thompson's lawyers by the prosecutors. So the prosecutors had evidence that showed to a scientific certainty that John hadn't committed the carjacking, but they didn't turn it over. That set off a huge set of events. Obviously, from our perspective, we were thrilled. We were back in the game. It didn't go to the innocence in the murder case, but remember how significant a role the carjacking played in the murder case. So the execution was stayed. We went to the district attorney, Harry Connick, the father of the jazz singer, Harry Connick Jr., and Connick agreed to put off the execution, convened a grand jury to investigate his own office's conduct from many years before, and ultimately the carjacking conviction was set aside. Because the prosecutors in the two cases, the carjacking case and the murder case, were the same people, we said to the judge, "Judge, this carjacking case was part of the strategy of the murder case. It's the same prosecutors. We want access to the district attorney's file in the murder case." And the judge granted us that access. And what we ended up getting was, after significant investigation and review of the prosecutor's files, was significant evidence that I'm going to show you in a minute established very clearly that John Thompson was not only not the carjacker, he was also not the murderer. Let me go back to the map. What we had, among other things, if we go back to this map, remember looking at the bottom of this graph, Freeman said that his car ran out of gas somewhere in the lower part where that green box is, and that he ran home. The first thing we found was that Freeman had told an informant that he didn't park the car at the bottom of the screen. He parked the car up at the top, up by those two big red boxes. And secondly, that he hadn't run home, he drove home. Now, you might say that doesn't sound like much, and in and of itself, it's not that significant, but there are other facts. If you take a look at the smaller red box, the police had information about a woman by the name of Sherry Hartman Kelly who lived in an apartment where that small red box is. And she said that when the shots were fired, she ran to her balcony on the second floor of her apartment, and she saw running a man who she described as being 6 feet tall with close-cut hair with a gun in his hand. And that this man looked up at her, she looked down at him, they made eye contact, and he ran basically in the direction of those two boxes, two red boxes. There was also a police report in there of two people, the McAllisters, who lived in the smaller of those two rectangular boxes. And they said, when the shots were fired, they heard one set of footsteps running, they heard one car door open right outside their apartment, they heard one car door close, and they heard the car drive off. And then finally, there was a document that showed that Kevin Freeman had told another witness that he had been seen leaving the scene by a woman. So who was that woman? It was Sherry Hartman Kelly, the woman who lived in that building who had made eye contact with the armed gunman. The description of the perpetrator was incredibly important. Remember, Sherry Hartman Kelly, whose existence was never disclosed to John's lawyers back in 1985, described the lone gunman as being 6 feet tall with close-cut hair. This is Kevin Freeman. His picture was taken when he was arrested. He's 5 feet 11 and a half inches tall. His nickname was Kojak because he kept his hair short. And you can see, is that the description of a man with close-cut hair? John Thompson, I'm going to show you his picture in a minute. Remember, the arrest was, or the murder was December 6, 1984, and he was arrested 6 weeks later. Fortunately, John was arrested for a traffic violation 6 days after the murder. So on December 12, 1984, he was arrested for a traffic violation. And this may have been one of the most fortuitous arrests in history because his mugshot was taken 6 days after the murder. And I'm going to ask you one question. This picture that you're going to see, the picture of a man with close-cut hair.